Hi, Mikhail.
Hi, Rashid.
How are you today?
Very well. A little bit tired, but that's the nature of the game. Just in from court and looking forward to sharing some insights with you on this wonderful platform, talking about wills, probate, and other matters at the end of life and how we can actually provide some sort of solution to person.
Thank you. I would like to begin by thanking both yourself and our audience for joining us today on the podcast. Before we begin, just some quick housekeeping. Firstly, we would like to mention that the contents of this are just us having a conversation. Any responses are for information and education purposes only. They do not constitute formal legal advice. The facts of each case vary. So if you have a legal query, please obtain specific legal advice valid to your individual circumstances. Vera, the host, or our guest would not be liable for any damages or loss caused. Secondly, we have received a number of your questions before as part of the registration process. We'll take them on as we move on and attempt to answer as many of those as possible. If any of the audience have any other questions, please feel free to put them in the comments and we put them on as we move on. Mikhail, could we begin by just a brief introduction about yourself, and just share your experience about yourself and your entry into the legal profession?
Thank you, Rashid. Well, my name is Mikhail Charles. I'm a barrister at Three Bolt Court Chambers, and we're headquartered in London. By way of nationality, I'm from St. Vincent and the Grenadines, which is a beautiful island in the Eastern Caribbean, where I grew up, attended secondary school, A-level college. Thereafter, I did my LLB at University of Wales, Cardiff. Then I did the English bar at City University. And then thereafter, I did a master's at Nottingham Trent University in corporate and insolvency law. Along the way, I admitted the bars of most of the Eastern Caribbean, starting from St. Vincent, Grenada, which is the most southerly island, ending at St. Kitts and Nevis and the British Virgin Islands. I'm also licensed to practice English law here in London. And from London, I maintain what is turning out to be a pretty active chancery practice. Chancery being a little bit of a Latin term, but pertaining to what is really private client work, both contentious and non-contentious.
Very insightful. If I may ask, what made you choose the law as your profession? Did you always know as a kid that this is what you're going to do, or is it something
Sure.
realization you came onto later?
Pretty much. I think, especially those who may know me from when I was in primary school, I was always that mouthy chap. I wasn't rude, but I certainly had a plaster for every sore.
I like that.
And things just evolved organically from there. Initially, I wanted to do medicine, but that didn't work out. Then I wanted to be a diplomat. Then my scholarship fell through. And then I found myself working for the National Bank. And I was seconded to the legal department. And then I went on to a jury. And then I was just like, this is the universe is pointing me too much in one direction. So let's just bite the bullet.
They all feel like quite all of those, those intellectually rigorous professions. It's like, all kind of fields where you like to, just kind of have that kind of intellectual challenge a day-to-day basis.
Well, look, I brand myself as someone who is solutions orientated. I like to find a solution. That solution could be litigation. It could be working a settlement out because I'm a registered mediator. It could be one of many things, but there is a solution available to someone.
That makes sense. I'm sure our audience are kind of dying for us to kind of kick in and get into a little bit about the wills
Yes.
and probate section. I think to kick off, I'm sure people are wondering when the right time is to start thinking of making a will. Could you shed
Right.
some light on the importance of early planning potentially?
Well, I think before we really get into that, we have to define what a will is. And, the formal definition is that a will is a declaration of a testator's intention regarding how they wish the estate to pass on death. Put simply, it's a written document that informs those who you leave behind upon your demise or upon your death what to do with all of your goods. Those goods could be real estate, it could be personal property, it could be even digital assets. but what happens after you depart this side of life? As with anything, life comes at you in stages. When you're in your 20s, you may have some limited asset. A basic will would, ensure that these go to your desired recipients. Then a next phase of your life, 20s, 30s, 40s, you may be thinking about starting a family. You may be thinking about getting married. You may be thinking about moving countries. You may be thinking about upgrading yourself in terms of the asset class that you may have. Those sorts of considerations will then require an upgrade or a different type of will as you try to future proof your life. But then again, into the twilight era of your life, maybe around 60, 70, you may wish to consider updating your beneficiaries. Do you have children, grandchildren? Do you have charitable causes that you want to contribute to or donate to? Do you have a retirement plan? What, do you need medical care? What would that look like? Who would take those decisions? So my general advice is that depending on the stage you are in life, you should be updating your will maybe every 5 to 10 years.
Very insightful. It feels like it's quite like one of those living documents, right? You make one as early as possible. In
Yes,
most cases, I think you require to as well. If you got life insurance, they will make you do a will. If you're buying a property, you will have to most likely create a will, and then maybe
right,
update it every 5 years. It's odd how we know a lot of people who kind of push it forward significantly, just don't do it early on, and I think it's
right.
because it scares people to kind of envision their own mortality a bit. I
It
make
is,
it's
yeah.
building
And
up on. Sorry, go on.
yes, I agree with that. I mean, death is one of those things that still causes a lot of fear. There's a lot of taboo surrounding it, but it's better to I always tell my client, front load the issue, put the love and care that you have for those who you want to leave behind or your beneficiaries. Put that to the forefront of your mind. And I think that would help guide your concerns in trying to make the process as streamlined and as easy as possible.
That makes sense. For our listeners, could you outline the practical steps involved in creating a will and perhaps emphasize why, being clear in that process or clear in your will is so important?
Well, yes, it's important for the following reasons. Now, in order for a will to be legally enforceable, there are a few requirements that have to be met. The will maker has to be over 18 years old and be of sound mental capacity. So that means that they need to understand what exactly they own or may have an interest in. They must understand the effect of their decisions. They must appreciate any potential claims against their estate. So, for example, if you have a mortgage, if you have a personal loan, these things persist post death. They follow into your estate and can be traced into your estate. Next, I think a relevant consideration would be that the will must be properly executed. That means that you, as a will maker, has to or have to sign in the presence of two independent witnesses who must also sign to confirm execution. The will also must be clear on its face, meaning what? It must demonstrate clear intent to dispose or to give away all of your assets upon your death. But there isn't a set formula of words because, well, people's situations differ. It's a very subjective thing, which I think we could touch on whether or not you need a lawyer, but we will get there. But no specific wording is mandated. All that is mandated is that there must be a very clear intention to dispose of all of your assets properly witnessed on your demise. And you can even research it for yourself. So the test is in a case called Banks and Goodfellow, meaning what? The testator, at least on the English law. And I can confirm, I think it's the same around the Commonwealth, places that follow common law. You need to understand the nature of your act. You need to understand extent of your property or other assets that are being disposed of. And you need to be able to comprehend and appreciate the claims to which a person making a will ought to give effect, meaning be aware that whatever claims that may against you in life can follow you or into your estate of death.
Quite insightful. Yeah, that makes a lot of sense. I think definitely something we all need to kind of consider and keep updating. One of the questions we received quite a few times, and I'm hoping this is because the audience is prudent, is what is the most tax efficient, mechanism to set up a will? And are there any strategies people can adopt just to make sure that, it's just good tax planning in their will?
Well, again, broadly, you have to record where you're domiciled. What that means practically is where your primary residence is. Now, I appreciate that domicile and residence are two separate issues, but generally, if you were living in England and Wales and your life is here, it could very well be that you satisfy both the residence and domicile tests, meaning that your estate or whatever you leave behind could be subject to what is called inheritance tax. Now, generally, for UK domiciled individuals, inheritance tax is chargeable at about 40% on their worldwide assets above the nil rate band, right? So the nil rate band, that has a particular value. So anything above that, 40%. But if you're not domiciled in the UK, then you only pay inheritance tax on whatever is here in the UK or UK or United Kingdom assets. But as well, you could also use what is called excluded property rules. But that's generally for if you're a non-domiciled person to avoid inheritance tax. Now, you would have to take very good care with your will drafting to ensure that the residence nil band or the RN could provide an additional inheritance tax threshold in order for you to pass on residential property and residential property only to your direct descendants, meaning son, daughter. That's about it. Another strategy that you could employ is perhaps using the concept of an absolute gift. So if you give an absolute gift to your spouse or civil partner, that's generally exempt from inheritance tax. But there are other alternatives. So for example, you can use a life interest trust to protect assets for your children, but that would also give you the ability to qualify still for the spousal exemption. But then you could also then use a discretionary trust. A discretionary trust could provide some flexibility, meaning that the trustees can apply your wealth to your beneficiaries as and when needed. But that simply means that there could be an ongoing inheritance tax charge. There's a little quirk on the English laws. For example, if you make a gift that's potentially exempt, could only be exempt if the donor survives for 7 years. So if you make your will to 2024 and you give a gift today and you live for another 7 years, well, that could become exempt. But if you pass away before the 7 years and the will provides for the PET or the potentially exempt transfer tax to be paid from the estate, then that could create a tax-free legacy. There are other things, for example, business property relief, agricultural property relief, charitable relief. So, for example, if you leave 10% of your entire estate to charity, then that would reduce your inheritance tax rate from 40% to 30%. But again, this calculation can be very complex. So you may have to engage the services of an accountant and or a specialist solicitor or barrister. There are a few more strategies, for example, lifetime gifts, trusts, will trust, deeds of variation, and gifts and downsizing. Make a note about downsizing and why people would downsize. Now, generally, the cost of elderly care is very expensive. So you could very well think that you can, maybe if you have a big 6-bedroom house, you could sell that and move to a 2-bedroom flat on the ground floor and have some liquidity to use for your carers or other forms of medical assistance coming towards the end of your life. So but again, the best strategies all depend on your particular subjective personal, financial, and family situation. But if you have a plan now to mitigate your risk, lifetime planning, plus tax relief and charitable gifts, you could very well minimize your inheritance and other tax exposure.
Very insightful, Mikhail. And I think just, getting all the advice makes me kind of comprehend how complex this area really is. What's your view on, so we've seen, as we hold a legal tech platform as well. What
Yes.
we've seen is quite a few DIY will making solutions in the market. And
Hmm.
on the face of it, quite, I think, simple to, you can download for,
Yeah.
XP and maybe setting up yourself. I think some vendors such as British Heart Foundation also have like a very vanilla kind of format they help
Yeah.
assist people in. What's your view on DIY, just make your will at home kind of solutions?
DIY would meet all the necessary formalities, right? So under the Wills Act 1837, so just that should tell you the antiquity of our probate law. Once you meet the four corners of that act, you're fine. But again, that's not tailored to you and your circumstance. No, I would rather much prefer if you spend a few £100 to get quality advice now, then have your estate be burdened to unravel those issues after your death, putting unnecessary stress, legal considerations on the backs of your beneficiaries. Forewarned is forearmed.
Agree. No, I completely agree. I think it's just some of these sectors, right? So you've got legal, you've got financial,
Yes.
you've got medical. The cost of going wrong is so high that what it makes sense to get professional advice.
Professional advice, yes.
Mm.
And I agree. I mean, the complexity of the tax rules alone, that warrants professional advice. Now, you could have liquidity concerns. So, for example, you have a piece of property. Now, that can, I mean, if that property rises maybe 30% in 10 years and you pass away and you still have to pay inheritance tax at 40% on that, who's going to come up with that slush fund? Your kids? Do your kids have family? Would they be in school? Do they have enough in their piggy bank to pay 40% tax? I mean, there are a variety of things that need to be considered because you could very well have to actually sell the house in order to pay the income tax or the inheritance tax. But then that deprives your beneficiaries of an asset. There could even be family conflict, and let's not shy away from it. Beneficiaries, may not agree with or understand your particular set of wishes unless it is particularly set down on paper.
Now, I completely agree. I think just to kind of add to it as well, just the marvels of modern healthcare, we tend to live a lot longer now. So
Indeed.
90 is very normal. And it's also very likely that as we grow older, our needs for care would increase. And someone, who's worked in the care sector, or care adjacent, sector for a number of years, we've seen this more and more. Healthcare, elderly care, nursing care, quite expensive. And especially if you're above the threshold, I forget what that is, I think it's, don't, hold me to it, 18, 20 grand in savings. If you're over that, just really expensive, fees for nursing homes. So it makes sense to plan early on because most of us will likely have to be in that position, in circa 50, 55 years time.
Yeah, and as you rightly said, look, people are living longer, but the quality of their lives may not be necessarily the best. You could have very severe mobility issues with all this pollution that's around us, respiratory issues. Sometimes even if you're in the pits of health, you still want your children, your grandkids, your great grandkids, you still want to have someone pop around at least once a week, ensure that the washing is done, etc. Because you slow down as you get to end of life. And I think those are the concerns. I mean, not to be morbid, but to have, those are some of the concerns that would actuate anyone, and in my professional opinion, should encourage you to plan your affairs accordingly.
Yeah, absolutely. I think spot on. And it's it's a little more, but it was also it's really doing it at the right time as a gift of love to your
Yes.
beneficiaries, right? It's one less thing they have to worry about in their lives. So I'm with you. Let's pick up one of the questions we've got as well. I think they're
Yes.
kind of we can springboard from here. It's now two questions. Hi, Mikhail, two questions. What is the process usually followed or guidance provided to enable a testator to accurately include all the possessions in their will? On average, how much does it cost to make a will? That's number two. So
Okay. So I'll take the second question first. Look, you approach a professional, they could give you a fixed fee, or it could be, depending on the complexity, it could be a variable fee. I know our chambers, we have several barristers here who can be approached on a direct access basis and who may offer a fixed fee uh, provision. Now, there's a typical checklist to ensure that all of your possessions are encapsulated in your will. There's several professional organizations, for example, the Society of Trust and Estate Practitioners, of which I'm an associate member. They have a very good checklist that I think is available for free online. So you can just Google that and find. And there's some things. These are some of the things that you find on the checklist. You'd find things such as your personal circumstances, your that means your marital status, previous marriages or civil partnerships. Why did those previous marriages or civil partnerships end? For example, did someone die? Did someone get divorced? Who are the children or who you treat as children? Do you have any dependents? Do you have any family conflicts? What are your assets? Do you have a home, personal possessions, cars, investment, bank accounts, any other assets in which you have a business interest? Crypto, your iTunes account, your Apple account, your Google account. Do you have a pension? Do you have life insurance? Do you have an endowment plan through your work, pension plan through your work? How do you own those assets? Do you own it in your own name? Do you own it with somebody else? Who are the beneficiaries to that? Do you have any debt or liabilities? I mean, the most obvious one would be a mortgage or a credit card. But do you owe any other bills? Do you expect any increase in your assets before your death? For example, are you inheriting anything else from anyone else? Are you expecting any gifts? Have you won the lottery? There's so many things that go into it. Have you made any gifts in the last 7 years? Remember, we were talking about the potentially exempt transfers earlier. Do you have a pattern of giving? Do you have any anticipated lifetime gifts? Do you have any charities you support? If you're a spiritual person, do you support your church, your mosque, your temple? Who are your executors going to be? And that's very important. Do you want to have someone that's related to you? Someone that you know personally? Or do you want a professional executor? How are those fees going to be satisfied? If your children are under 18, who are you going to appoint as guardian? And of course, do you have any pets? Who are going to take care of your cat, your dog, your fishes, any other sorts of pets that you may have? What about your funeral and burial wishes? Who's going to pay for it? Have you been paying into a plan? Do you want to be cremated? Do you have a plot? And then who do you want the rest of your estate to be left to? Who was near and dear to you? If you have no one, do you want to leave it to the Red Cross or the Red Crescent? Other forms of charity? Those are some of the key things that you'd find in a checklist. So if you start walking through that checklist, you then start to but you then start to begin to appreciate not only the complexity, but the simplicity of it. This is what you have accumulated over a lifetime. And this is what, after that lifetime is ended, what you want to dispose of to those who you love and care.
very helpful and very comprehensive. Thank you. Clearly, a lot goes into putting this together. And I'm sure that's reflected in, just the cost of drawing up the will as well. If it's simpler, it's very vanilla, I think could be more fixed kind of version. If it's more complicated, then clearly, no. I think the next question we have is can we include overseas assets in our UK wills?
Okay. Broadly, yes. But then again, that means, of course, that's a typical lawyer answer. It depends. I'll tell you why. Now, you can include your overseas assets but it simply means that you would have to get something called a reseal in the other jurisdiction. So, for example, take for example my native jurisdiction, St. Vincent and the Grenadines. Now we're a common law country, right? We're a former British colony, so it's usually very seamless. So you once you get the grant of probate with the will attached here in England, you then take that document and you carry it to the overseas court registry and will say, this is the last will and testament of, let's say, Mikhail Charles. We know what he wants to do with his English estate, but he has also given specific instructions about his non-UK estate. Can you reseal this grant? So it becomes a rubber stamping exercise whereby the local court stamps the UK grant, and that gives legitimacy to the office holder, that is the executor of your will, to deal with the assets and take charge and take ownership of the assets in your name that you have devised. That's the technical term, meaning that you have planned for in your will. But generally, in some other countries that are usually not common law countries, and what is generally advisable is if you have a will to deal with that specific asset in that specific jurisdiction. Now, what may sound like a duplicating process, when you start thinking about the time, the hassle and the legal fees, and the other expenses that could go into having one English will and then taking that will across the world, as opposed to having several different wills in each jurisdiction. You may have business and or family and or assets. It could very well be or could very well represent a savings to you to have different wills for different jurisdictions.
Very helpful, because I wonder also, right, the law in jurisdictions can vary, especially
Indeed.
jurisdictions which apply a more theological version of the law, which is
And you raised my antenna there. No, you say theological. So, for example, what you would find in some countries that have a theocratic version of law is that you have forced heirship rules. So, for example, those particular types of laws, or even in civil law countries where they're forced heirship, meaning that you can't, in English law, you have what is called freedom of disposition or freedom of testamentary disposition, meaning if I own this green tie, I can give it to whoever I want when I die. But in other countries, because of forced ownership or a theocratic view of the law, they may say that this green tie can only go to my direct descendants. And if not to my direct descendants, it goes to my blood relations and it will go in a predetermined share. For theocratic, they may say a male may inherit more than a female or vice versa. So to get away from all of you may very well want to have specific plans for your specific life, which comes back to the earlier point. Get that advice early on, the same way you take your car to do your MOT.
I love that empathy you said, absolutely. And the question we've got, and I think is one of the more practical ones.
Yes.
Are there any providers that would assist with safe custody of the will once it is prepared? So I think the meaning is to document, right? The will document, the physical document.
Now, generally in the United Kingdom, there isn't really a will saving system. So what you generally find is that people deposit their wills in a safety deposit box at the bank, or they enter into a custody arrangement with a solicitor or a professional trustee. It could very well be one of those three types of arrangements, but generally there isn't a central storage system or central filing system for your will here in England. There may be in other countries, but generally what you would generally do is once you've finished executing your will, you give a copy to your intended executor. And of course, you have that conversation with your family.
Yeah, I'm with you. Thank you. Very valuable information, Mikhail. Thank you. From your experience, could you share some real life challenges that people often face during the will making process? And what might be potential pitfalls to avoid in making a will or in the will making process? I know it's quite a few questions there, right?
Yeah, I think the biggest issue is understanding what your assets and liabilities are. I think that's the biggest issue. One. And number two, trying to front load the considerations of who benefits and in what share from your estate? Are you going to give your first son the majority of your house? What about your little daughter who's just been born? Would her needs change over time? Would your son's needs change over time? I think that's the biggest issue. Of course, that could then lead to family friction or family conflict. And indeed, that could set up a potential Inheritance Act claim against you, meaning one of your children or one of your dependents could come and say, well, this will fail to make, and then even when you're gone from this world, your will is still being contested as to what exactly did you mean by the terms of your will. So again, you need professional advice to be able to nullify or blunt the potential for any Inheritance Act claims against your estate. I think maybe to answer broadly the second limb of your question in terms of some other challenges and how you mitigate those, again, looking at checklists and thinking about what exactly you hold, think process, right? What do you want to use a Caribbean term? What do you want in people's hands at the end of the day? Is it money? Is it house? Is it vehicle? Is it the proceeds of your life insurance? Is it access to property overseas? What do you want? And I think if we actually start looking at establishing the four corners of what exactly people want, then that could help us understand the processes that need to be put into place in order to allow that to happen.
That's essential to know, Mikhail. We often hear about wills being contested.
Mm.
Maybe just kind of your guidance as to what are the reasons behind these being contested, and is it lack of clarity? Is it just people being unhappy with the content of the wills, and just kind of what advice you might have in reducing those
I
disputes?
don't want to laugh too much because that is one central plank of my practice, both here and overseas. Look, after you die, people generally have rose tinted glasses about the relationships around them, and that's a fact. So somebody ways that you're going to contest the will. Some barrister, some solicitor is going to write you a letter and say, but hang on, this will wasn't properly executed. So it's an invalid will. So it means that what you say you would have left has not been left. Was it witnessed by two people or just one? Does it fail? The most common one is lack of mental capacity. So remember we talked about the Banks and Goodfellow 3-stage test. And one of them was that the testator or the will maker must understand the nature and extent of their assets and claims. But if I'm laid on my bed at 95 years old and I'm shaking to sign, and two other people say that, did I have the mental capacity to understand my own deed? That's one of the challenges. If I'm incapable mentally to make a gift, then certainly that will must be invalidated. Another aspect of that is undue influence. Was I pressured? Let's say I have one of my children living at home with me, and they are the ones taking care of me. But before I was bedridden, I had a will that says 80% of my estate to go to one of my other children. But then thereafter, while that child is living with me, bathing me, etc., I change it to make it the other. 80% goes to that child, my new favorite child. Then the old favorite is going to say, but hang on, there's something going on here. Was he coerced into making this new disposition? Another way is by saying, look, well, the technical, the last case that I want here. I get excited by this. Now, Section 21 of the Wills Act says that any change to a will must be initialed by the testator and the witnesses. So any unauthenticated alteration to that will makes a reversion. So we could either invalidate the entire will, or we could invalidate that particular change and revert it to the initial position. Another way of challenging a will could be incorporation by reference. Now, that means that if there are documents incorporated into the will, so for example, you say, I want to leave these share certificates in an offshore company to my son who I love and care for, and those share certificates don't exist, then that's the ground for challenge, meaning that that specific gift fails. Another challenge could be a revocation issue. So, for example, you have made a later will, but then the later will disappears, but people know of the later will, but then someone comes and claims on the old will that they have in their possession. What attention is? Is that a question of fact? Where do we get the evidence from? Is there an argument over the intent of the testator or the will maker there? I think finally, there'll always rectification and interpretation disputes. So, for example, if there a typo that says boys as opposed to boy? Is there a typo that says charities? Is there a typo that says trusts when it should only be one trust? That sort of thing. And there's a broad power in England and Wales, at least, under the Administration of Justice Act. I think it's sections 2021 and it's the 1982 Act to allow for rectification, meaning to put the deed correct and to act and to get a ruling on the interpretation of a particular part of a testator's instrument that one can deploy. But again, you need to have specialist advice.
I'm with you. No, that makes loads of sense. In the circumstance where the court holds that a will is invalid, what happens next?
Could be a variety of things. It could very well be that the court then says intestacy rules apply. If you get the will knocked out, then you become an intestate, sorry. Or depending on the type of dispute, it could very well be that new beneficiaries come in, as opposed to what the old will said. Or the court could appoint a new administrator or a new executor. Yeah. But usually what happens is that the tax situation gets messed up. So you could have higher taxes on your property and you could have more delays on it, extra legal expenses. Now, if intestacy rules apply, now intestacy simply means that you don't have a will. So the common law rules would apply, meaning usually it's your relatives would benefit from your estate. Now, common law and statute to a lesser extent defining who are your relatives. And it could be your direct descendant, your brothers of the whole blood, meaning both mother and father, or your siblings of the half blood, meaning you share one parent with them. The language is very gendered. The language is not as modern as one would like, but all intestacy means relatives. And if they can't find brothers, sisters, children, etc., then it reverts up your line. It goes up to your father's line and or to your mother's line. So you could very well be your cousins benefiting from that wonderful mansion in Mayfair that you didn't protect efficiently with a properly executed will.
That makes sense. Reminds me of Downton Abbey, yes, the cousin know what happens to be a solicitor, by the way, somewhere in Manchester. We'll pick up one of the other questions. Thank you. Very insightful, which we've got. What happens to my estate if I die without making a will? Which is
I
what
think we covered that. Yeah, I think we covered that intestacy. Yes.
The next one is, does it matter where a will is recorded? I'm a resident of the UK with no immediate plans on leaving the country, but I'm a citizen of another country. Where should my will be registered / recorded? I think we kind of covered this as well.
Yeah, we kind of covered that. So broadly, it depends on where you're domiciled and it depends on where your assets are located. So if you have assets here in the United Kingdom, I would advise that you have a United Kingdom will, one that is executed on the laws of the United Kingdom. Because it could work the other way, you could have a will that deals with your global estate in another country, and then it's resealed and administered here. But again, that's a layer of expense through a solicitor.
No, I agree. And I think definitely getting that multi-jurisdictional kind of advice early on helps, because just from, my experience in a different life, because a lot of foreign jurisdictions also have treaties where they recognize British or UK law. So I assume you could have a will which was enforceable here, and maybe it's under the treaty, it's also enforceable there. So it can. Sorry, go on, yeah?
Well, look, I don't know if I would approach it from a treaty basis just yet. I mean, there's a general rule of public international law that your disposition, if if you see it in your disposition or in your will that you want to dispose on the laws of country A, then England and Wales would respect that. So it would displace English rules and bring in country A's rules to whatever assets you own here. But it must be under your particular will.
I'm with you. No, that makes sense. Let's look at one of the other questions we have, which is I'm a 24-year-old who started a job a while ago. I've got a few savings saved up. Is there a certain point or where you would recommend to start thinking about making a will? And I think we've kind of touched on this, but I think
You touched
yes,
that, yeah. And I'd reemphasize, you could start thinking about that now. You've got some savings. Because what's going to really happen? You're 24 and you pass away, God forbid. Those savings are going to be swallowed up by fees. I mean, you could get around it by specifying a beneficiary on your bank account to whom the bank would release the funds without the benefit of a will. All they have to do is produce your death certificate. So that can ease it. But then again, what else do you own? Maybe who's going to deal with your online life, your other assets, your digital assets? Who's going to deal with that? Right? You need to have an office folder in place.
and I think the digital assets component is quite an interesting one as well to
Yeah.
add. It's not something our parent generation used to have to just plan for, but now all our lives are documented, right? Our digital presence footprint is so important to all of us. It's lives cataloged, so who gets to control that and the information? It might be very sensitive, might be commercially sensitive, might be just private in general. So how to
So your digital assets or your digital footprint, and I think as the metaverse becomes more in vogue, the general Internet of Things become more in vogue. In fact, the way that we even say becomes more digital. The ability for you to be able to dispose of that, because when you die, your passwords die, your two-factor, three-factor authentication dies with you. Then are you going to approach Apple, Facebook, LinkedIn, all these sorts of platforms that hold very valuable personal data? If you don't have an appointed executor, if you don't have something that legitimizes a third party to interface with those platforms. And this is where a will comes into to effect. In fact, you could even have a digital will or digital provisions with Facebook, Apple, and other platforms to say, this is my nominated person in case of my demise. And they would have their own procedures to verify that person and to verify the actual fact of your demise. So my advice would be to make that a part of your estate planning. So we can readily identify executors. Is that executor also empowered to deal with your digital asset or not? I would suggest that that executor be empowered to deal with everything, digital and real life.
very interesting. But just out of curiosity, I didn't really thought about how as the metaverse becomes, some version of the metaverse becomes, more prevalent in our lives. And as, digital offerings have real tangible value and can be exchanged and bought, which is, I assume, the vision, what happens to all this? Maybe there's scope to kind of build like a digital slash quasi legal technical solution over here, which kind of plugs into all of those. Definitely a startup idea over there.
I too have done consultations in the metaverse. It's something that I'm looking at because you're not restricted by borders. So it's literally, with greatest respect to the platforms, it's really it's a fancy Skype meeting basically. You've got your controls, you got your goggles on, and you actually see, and you can go for a walk with a client. It's really fascinating, really fascinating.
No, it absolutely is, and I'm sure as the space develops, just the law around here would also develop. We've seen quite a few prop tech kind of plays, startups come up, just building more in that space, building virtual real estate, and I'm sure as that happens, we heard of someone a virtual developer kind of building a virtual courts in there. So
Interesting.
yeah,
I wouldn't mind trying a case in the virtual space. Were there any more questions that we would have to?
I think we have I think we've picked most of the questions
Right. Right.
relevant. What I know we just almost at the hour as well. So last thing I'd like to ask you, and this is just, it always intrigues me is if you could leave us with like an interesting case you've done, interesting story in your legal experiences,
Uh,
a career at the bar.
I think over the past 10 years, I've been incredibly fortunate to have been involved in a lot of leading cases, at least commercially. Vincent Vince. I don't think it's a case, but I'm currently on a project that reports next month, and we're drafting a model law, a model company law, a model partnership law, and a model insolvency law for all of the states of the Commonwealth Caribbean. And it represents an opportunity to modernize our laws. What that means practically is that because many of the laws in the Caribbean are from the colonial era, and those company laws that have been updated not only from the colonial era, but into the early 90s or so, they take a little bit from Britain and they take a little bit from Canada. But what they don't do is that they don't integrate most of the islands as a single economic space. I think I'm very fortunate to be working on that project that reports to the CARICOM heads of government at the end of this year. I think that's my most interesting thing. In terms of, see, now we're talking about legacy. If this really takes up, I think that would have been my small part to play in helping to advance the economy of the Caribbean in general and the Eastern Caribbean in particular. So I think I think that's a pretty much the most interesting thing that I have going on at the moment.
Sounds quite
So
interesting. Absolutely right. And it's one of those
yeah,
things you're doing, something you're passionate about, and you know that, it's
yes,
gonna have a meaningful impact to so many people.
indeed.
It's I think the UK ranks quite high up, in terms of ease of doing business. And when they looked at the reasons, that's the law is simple, courts are fast, expensive, yes, but fast, very easy to set up a company, quite affordable to do it. Corporation tax is not less, but it's quite, we're quite lower than a lot of other jurisdictions, across the world. Let's just pick one final question, right? And this one's actually it's a mix of you've got some wills there, but potentially also some immigration thrown in. But I'll shoot it out your way. Hi, Mikhail. My children's named guardians in our UK will are not British citizens and are based outside the UK. It is possible that they might not have a UK visa to enter the UK at that point. So I assume this is the point where, God forbid, something unfortunate happens. In the unlikely event of both parents' demise, said unfortunate event, what would be the best way to relocate the children minors to their guardian? I appreciate it's not strictly, inheritance, it's inheritance with some.
I think you're going to have to appoint an intermediary here in the UK. Because if the children have their UK citizenship or the right to travel in and out of the UK, then there's an argument there that you can maybe get an emergency authorization from the UK border agency. But again, immigration is not my specialty. I think you need to have a strategy, and preferably with professional advice from a family solicitor, family and immigration solicitor, to allow those children or those minors to move across the border. And of course, the will would be important. The executed will would be important because that document would set those external parties up as being legal guardians of the children that are within the borders. So that will again is important, but I think you will have to appoint intermediaries.
Mikhail, we just about at the hour, so I'm gonna wrap up. Thank you to all the audience who've joined us today. Mikhail, thank you so much for your time and insights, really valuable. Fantastic to meet you, have this conversation. And please, thank you to everyone. And I'm sure, we will speak soon. Thank you.
Yes, you're very welcome. Thank you so much for having me. And of course, MOT your life, MOT your
Yeah.
estate.
I love that. I'm sure that's gonna catch on, I love it.
Indeed. All right. Thank you so much, and all the very best to you.